judgement Andhra Pradesh High Court has declared that the state has no competence to legislate on three capitals issue, and also gave different reliefs to the farmers who have given up their lands for purpose of construction of capital region Amaravati. We have no objection for granting relief to the farmers, but linking the issue of shifting of High Court from Amaravati to Kurnool, we have got reservations on the judgment. With due respect to their lordships, we want to submit that having High Court at one place and a capital in another place is not a new phenomenon. There are so many examples in independent India that capital is there in one city and a High Court is there in another city. Take for example Madhya Pradesh. Bhopal is the capital and Jabalpur, where the seat of High Court, main seat of High Court is situated. So also Uttar Pradesh. So also Karnataka. And even the small state like Chhattisgarh, capital is at Raipur and High Court is at Bilaspur. And there are benches also. So it is not out of place to mention the fact that having a High Court at one place and capital at one place will not do any hamper or will not hamper the development of any state. Instead, it will felicitate the equal development of all religions, decentralization of the administrative system, and important segments of constitutional authorities. That is, one at capital region, let there be Amaravati, and the main grouse and the grievance of the farmers was to claim compensation and not to shift to capital city. They were not speaking about High Court. And High Court, it is to be remembered that Andhra Pradesh capital was shifted to Amaravati in the year 2015, and capital was started functioning from there. And even according to AP Reorganization Act, establishing capital is different from establishment of High Court. Section 31 of the AP Reorganization Act speaks about the establishment of High Court. So there are two different things. We cannot club capital and the establishment of High Court. It is true that the earlier government, previous government, they got it High Court established at Amaravati in spite of the objections raised by Rayalaseema region people and also coastal region people like the Vizag area people because of political considerations. No doubt, the Amaravati High Court at Amaravati was constituted by way of presidential order. But that does not mean that it cannot be shifted to other places. And in fact, in Andhra Pradesh, the High Court, unfortunately, either the government or the parties concerned to the writ petitions, they did not bring the fact that there is a gentleman agreement as long back as 1937, that is Sri Bag agreement, which was effected in between Rayalaseema people and coastal Andhra people when they wanted to establish Andhra state, bifurcating, dividing from Madras. So there was a gentleman agreement. According to the gentleman agreement, if Andhra Pradesh state is formed, if capital is one capital should be located in Rayalaseema and High Court in coastal region, vice versa. So that agreement stands even today because the 1953 the AP state was formed. AP state was formed excluding Telangana. Then, as per the gentleman agreement, Kurnool was made capital and High Court was established at Guntur. So for 3 years, this same arrangement has been functioned, and thereafter, according to the linguistic state policy, the Telangana was also included and United Andhra Pradesh was formed, and then capital city and High Court were shifted there. But when the division of state was effected in 2014, again the status quo ante was restored. Status quo ante was restored of 1953 position. Therefore, again the Sri Bag fact must come into picture. But unfortunately, nobody brought to the notice of the Honorable High Court during the hearing of these writ petitions. And writ petitions wherein the farmers wanted to implement CRDA, Capital Region Development Authority, the act they wanted to implement, and the relief was given. We don't have any objection, and we are not even questioning the establishment of Amaravati, capital at Amaravati in spite of the opposition from the expert committee, Sivaramakrishnan committee. But the thing is, the linking that with the Capital Region Development Act, it is unfortunate, and it is high time that all the political leaders who have given consent, openly consented that they have no objection for shifting of High Court from Amaravati to Kurnool. All the parties, including the opposition, ruling party, everybody. So it is now time for them to stand up and see the hurdles which were created by virtue of this judgment are clear. And whether it is by amendment, going for the amendment to the AP Reorganization Act, or bringing pressure on the central government, where central government has categorically stated in the parliament that it is for the state government to establish High Court in whichever place it desires. So therefore everybody is giving consent, and now it is time all the political parties come together united and clear the hurdles which were created by legal hurdles, which were created by the judgment rendered by the Honorable High Court of AP, and therefore it is time for all the legal fraternity to come on one platform, and particularly in Rayalaseema region. And again they must educate the people, and because if institution is being deleted from Rayalaseema, then there is no prospect of any development for Rayalaseema region. Therefore it is a high time that not only the legal hurdles should be cleared, but also people must come together, unite to protect the interest of the Rayalaseema region, and see that the promise of shifting of High Court from Amaravati to Kurnool is fulfilled by the government and supported by all the political parties. Thank you.